All right, you can see my screen with all the sponsors or all the different logos there, I'm hoping.
Yep.
And we just went through the networking bit. Now down below where you see a little chat button, I've kind of marked it with red here. Go ahead and put in there your name, your company, your phone number, email, and your location. And at the end of the meeting, you should be able to click on that. And there's three little buttons. When you put in the chat, let me just make sure because things sometimes change a little bit. Now it looks like a file. Actually, it looks like a little file with the corner bent over. And if you click on that, it'll download as a text all the information that's in the chat. So if you put your information in there and somebody downloads it, now they've got your kind of virtual business card. And that way you can connect with the people that you met tonight. Okay, I always like to start the meeting with a little nod to Gene Garino, who we lost in 2021. Gene was instrumental in the founding of the REL Academy, the REL National Association, and introduced thousands of people to the model of the residential style assisted living. Because Gene, I got involved in this, and Gene's motto was do good and do well. So I always like to recognize him for what he's done for this industry. I always ask that you guys, if you want to visit our website, it's there at daalr.com. It's interesting. It wasn't on purpose, but that's pronounced dollar. So I always thought that was a little bit fun. And if you are in Colorado, it's important to go to this link here, the helpful links that's on the front page. And if you are an operator in Colorado, you want to pay attention to those very first two links there, the chapter 7 and the chapter 2. These are the regulations in Colorado. And if you're operating in Colorado, you need to know these like the back of your hand. So we just kind of gathered up all the tough links that are hard to find on the CDPHE website and put them all in one spot where it's easy to find. And that's what that page of helpful links is. And we always ask that you join our Facebook page, which is Denver ALR, and join the community and, just chat to each other. If you're looking for something, maybe you could find some information there. If you have a question, you can ask the community. And we thank everybody that has signed up on the meetup group. It just makes it easier to get this information out. We're actually 1,169 members, I think it was today. So we're getting there. And now I want to talk a little bit about our sponsors. The sponsors make it possible for us to do this at no charge to anybody. And these are our sponsors here. We'll start with Paul Ryan Construction. With 35 years of combined construction experience, the exceptional team at Paul Ryan Construction has transformed residential and commercial properties by bringing a high-touch, customer-centric approach to every engagement. On the insurance side, Paul Ryan's reconstruction and roofing expertise is a skill that many insurance companies actively seek out. Their reliance on Paul Ryan's experience in helping them write estimates has made Paul Ryan a well-respected, trusted expert in the field. And next we have Brett Chakavis with Assisted Living Mansion. Brett was actually our speaker last month. He's got great information, very energetic guy. And Brett's put together a really nice program for a high-end 16-bed model. And also on his website, videos, mostly geared to the experienced operators. So if you go to palm.university, you can get more information about what National Association, and this is the Residential Assisted Living National Association, which represents the interests of the small assisted living providers. Their mission is to help the small assisted living homes get the resources that they need and give them a voice on the national level, and improve the quality of service delivery throughout the industry with a national industry professional base. RALNA offers robust benefits to investors, owners, managers, and caregivers alike. And you can go to their website right there at ralna.com. And also we have the RAL Assisted Living Academy. We've got a link to that directly on our website. And if you're new to assisted living, this is what we always recommend as your starting point. So going through this course is the basic training for running an assisted living. So this is, they've got just the business basics. If you've never done this before, this is where you want to start. And next we have assisted living marketing with more than a decade of experience. They have customized services that work for small, large, and multi-location communities. Assisted living marketing is your trusted partner for the digital and print marketing. Oops, bumped that too quick. In the assisted living industry, and I'll have to say I've worked with a lot of web builders throughout the last 25 years, and they've been the most responsive people that I've ever worked with. So I call them up, I need a change, and bang, they get it done. So I highly recommend using them. They built probably about 4 of my sites, maybe 5. Next is Senior Living Administrator Coaching LLC. This is Janet Cornell. She's done many presentations for us. Janet provides consulting for your assisted living home here in Colorado and can provide the 40-hour administrative training, staff training, and employee file compliance and compliant documents. If you are in Colorado, it's always wise to hire Janet to come do a mock survey where she'll go through your facility and tell you everything that would be wrong if you had the state go through it. So it's much better to hear it from her than hear it from the state where you get written up. So that's Janet Cornell. You can reach her at, going the wrong way here, scac-janet.com. And next is the ICOR. This is the Investment Communities of the Rockies. And ICOR is Colorado's only nationally recognized and award-winning real estate investor association. Serving the Denver Metro, Colorado Springs, Fort Collins, Northern Colorado, as well as real estate and rental property investors across the state. I've been a part of ICOR for, I think, 12 years now. And it's just a great group. So if you are an investor, this is a great group to get connected with. And next we have Colorado's assisted living lawyers. They help people outside of Colorado as well. So if you have a problem with fair housing, for instance, HOAs, zoning, you want to call Michelle and Brian Pinkowski at pinkowskilaw.com. They help developers and operators of assisted living and group homes locate and establish their facilities so they can focus on the business of caring for people. They'll act as your advocate or work with you or your local council to encourage compliance with Fair Housing Act provisions. And kind of what that means is, if an HOA comes in and tells you you cannot do this in your area, Fair Housing Act outweighs everything the HOA says, outweighs the zoning. They can help you show how you can use those federal laws to assist you and have them on your side. And next, we'll talk a little bit about A Better Way Funding. And A Better Way Funding is a group that I'm involved with, and we do lease options for group homes. You can read about that at ralleaseoptions.com. Basically, we'll buy the facility and lease them back to an operator. They have an option to buy it from us in the future. And we also take investors. So if you're an investor and want to get involved in this passively, then you can give us a call. You can give me a call. My phone number's in there, and we can put you in on one of these deals. And I'll talk a little bit about my company, Grand Avenue Business Brokers, at A Better Way Realty, where I hang my license. I've got over 30 years of business experience, over 80 assisted living transactions, 180 million transactions. I'm a certified business intermediary, and I'm also a certified senior housing investment professional. And of course, I specialize in assisted living. So recent activity, and some of this is getting a little bit old, but we did, well, I don't need to go through all these, but we did close that 30-bed in Central Illinois, and There is still a 12-bed in North Metro Denver that's available, and a 15-bed. Actually, I don't know if that 15-bed in Colorado Springs is available, but we've got an 89-bed package in Eastern Colorado, and if you were to get that, you would have 66% of the market in a 6,000 square mile area. It's producing very well. It's a great opportunity to have a corner, basically a major market share out there, and you would rule the market if you were to pick that up. And sometimes we have the Colorado Assisted Living Association, a member with us. I don't see any of them here tonight, so we don't have any news from CALA, but I will say if you're an existing operator, this is a good group to be a part of. They do a lot of the legislation type work, and they're again a good group to be a part of. Okay, so I was at the Round.com last year, and I had a conversation with Kim Taylor, and I was so impressed with her. I've talked to a lot of attorneys throughout my years, and when you talk to an attorney, it's always best to find out what they do. Ask them what they do. My rule of thumb has been, don't ask them if they do this, because they'll always say yes. So if you want a divorce attorney, if they're a divorce attorney, they're the ones you want. If you want a syndication attorney, you want to make sure you're talking to a syndication attorney. If you want a business attorney, you want to find a business attorney. Well, Kim and I started talking, and I've talked with a lot of syndication attorneys, and she telling me things that I'd not heard before. And I thought, wow, this is great. I really want to get to know her better. So we're working with Kim on another project. We're probably going to use her on our next syndication because she's just wonderful. Got a couple of great books out, and working on the one book that I got from you, Kim. I haven't finished it yet. I should do the audio version because that's the only way I find time for that. But I want everybody to give a warm welcome to Kim Lisa Taylor. And Kim, you can drive.
I feel like I'm coming home a little bit here. I used to live in Denver. I actually went to law school in Denver at the University of Denver. And I used to live while I was going to law school at St. Mary's Glacier. So I don't know if any ever been up there, but there for a couple of years of law school, and then moved down into town over by the old Stapleton Airport when after it had moved, but shortly after it had moved. And anyway, I had fond memories of my time in Denver. So anyway, let's go ahead and I'll give you guys a little presentation, but there's going to be plenty of time for questions and answers after the call or after the presentation. How long do you want me to talk, Vern?
Oh, we've got, let's see if we did this for 45 minutes, and that would leave a little bit of time for questions. So somewhere in that range.
Perfect. Okay, that sounds great. How do I get this started? I guess I'll share my screen. Okay, are you guys seeing the right one, or are you seeing the presenter view?
Looks good, yeah.
Perfect. All right, great. Well, so I am the founder of Syndication Attorneys PLLC, which is a Florida-based law firm. I'm actually licensed in California and Florida. I started quite a while ago in 2008, I started in the syndication world. My husband and I went to a multifamily conference that was led by David Lindahl, and we signed up for his coaching program and actually bought a multifamily property. I was a fairly new attorney at that time. Law is my second career. My prior career, and while I lived in Denver, was as an environmental consultant. So I'm actually licensed as a professional geologist in the state of California. Still, in case I ever get disbarred or something, gotta have backup, right? So I don't know. But anyway, I I met somebody at the RE Mentor event. Well, first of all, we went to the Multifamily Millions. We learned, how to buy multifamily, and then figured out we needed to raise money, and I didn't know how to do that. And I thought that since I'm an attorney, I'll probably be held to a higher standard, so I better learn to do it right. We went back and went to a private money boot camp, and there I learned for the first time in 2007 about what is a security and what all this stuff means that I'm now going to teach you. So then I actually ended up working with the gentleman. His name is Gene Trowbridge. Some of you may know of him or know him. But he had a practice area in this field. And so he and I started working together for a couple of years. And then a couple of years after that, we started a law firm, Trowbridge and Taylor. And I worked with him for 8 years. And then in 2016, decided to move to Florida and start my own practice. And that's when I started Syndication Attorneys. So we've been around for a little bit. And I apologize, it is late here. I'm on the East Coast, but I know Chris is also here from Charlotte, so he can prod me if I fall asleep on you guys. I won't. But anyway, our team, we do have 12, 13 people working with us at any given time. Pretty well-rounded staff, but a lot of attorneys. I tend to bring in some more experienced attorneys just because I like to surround myself with people that know more than I do. And, as I know a lot of you guys do too. But I've been the responsible attorney for, I think, over 450 securities offerings at my last count, enabling people to raise over $4 billion. Because this is all that we do. So a lot of other attorneys do syndications, but they don't just do syndications. So we are, there's no specialty area, practice area for it, but that really is our niche. And so I have written 2 Amazon best-selling books. One is called How to Legally Raise Private Money. That's the first book I wrote. That one is the Beginner's Guide. The other one is How to Raise Capital for Real Estate Legally. Actually, I have that one here right now. I think that's the one that Vern has, and this is the one that is on Audible. It's a little bit longer. I like to think of this as a desktop reference. The first one is more like a how-to guide for syndication, but I don't have anything about assisted living in the first book, and I do have it about it in the second book. There's some deal structures in there for it. Either one of those books is a good resource for you. And the nice thing about this book is that it's like an encyclopedia. I wrote the table of contents very detailed. So Vern, you don't have to read the whole thing if you don't want to. You can just go to the table of contents and read what you want. But I always encourage everybody to read the sections about splitting money with investors and structuring your deals, because that really was one of the big mysteries for me. When I learned how to do this, I thought, okay, well, I have no idea how to fairly split money with investors, or how I would structure a company to, incorporate investors and what that would look like. And so that to me was a big mystery. And so I'll try to kind of take some of the mystery out of it for you guys, so you feel like, okay, at least I don't have to feel like it's insurmountable. But if you guys want a free copy of this book, I'll now show you this again at the end. But we do have free copies for you at our website. I think there's a digital copy there. You can also buy them on Amazon if you prefer to have it on Kindle, or you want the soft copy. But just go to our website, either scan that or go to syndicationattorneys.com. There's a free book tab, and you can get it there. So these are just some of the other attorneys that work on our team. Mola Bosland is one of our main attorneys. She's been with our firm for almost 9 years. Jason Hargadon, who we brought him on, he does more small business type offerings, but he also does real estate offerings too. And he brings a wealth of information. And then Michael Fugler is done everything under the sun, including representing mafia members and cartels and things like that in litigation. He's just been around for a long time, and he's done a lot of stuff. And then Judith is someone we brought in. If you ever hear of somebody who's doing a fund of funds, or you're interested in doing a fund of funds, you'll want to contact us and have a call with Judith, because there's going to be some additional regulatory compliance you have to do. Just like owning an assisted living facility, there's different licensing rules that start to apply when you get into a different area, and this is one that starts to trigger those. So if you hear about that fund of funds, the issue there is that you really have to become an investment advisor, and there's different levels of what that entails based on what your state requires until you get to a certain level of assets under management, and then you can register with the SEC. So, and then Krisha, I know Vern has talked to Krisha. She's our business development director and client success coach. If you ever find yourself having a mental block to getting ahead, you just feel stuck in a rut, something like that. Krisha actually has her own mindset coaching program, but she also works for us, and we'd be happy to get you, into one of our programs where you can get a call or two with her. And she's pretty good at kind of digging through that and helping you get past those barriers. We did a podcast on that. We have a podcast called Raise Capital Legally. And one of our most popular podcasts was the one that I did with her, and it's called it's something about how to get past the mental barriers that keep you from getting what you want in life. And I encourage you all to listen to that. And also those our podcasts are available on our website. So we already kind of ran through those statistics, but so I'm not your attorney, but yet would like to be. So, this is just for educational purposes, but I hope at some point that we have an opportunity to talk to each of you one-on-one and help you get further along in your goals. So how to structure your deals. Let's start with how to structure, and then we'll talk about securities laws. Sometimes I do it the other way around, talk about securities laws first, but I kind of think sometimes it flows a little better this way, when we kind of lay the foundation and then overlay. Okay, so here's what we're doing. How do we have to then incorporate securities laws with all of that? So typically, you're going to create an entity that has at least a typical syndicate. Like if you're just going to buy a multifamily property, you would create this syndicate entity, which is going to be a manager managed LLC. And then you create a separate asset management entity. When you form an LLC, or when we form an LLC for you in any state, we get to pick whether the LLC is going to be managed by its members, or is it going to be managed by a manager? When it's managed by its members, that means that all of the members are technically considered to be managing members. So they all have the right to open and close bank accounts and to legally bind the company. When we create a manager managed LLC, only the manager has the right to do those things. So the manager runs and operates the day-to-day, and the members, those are all of your investors and your other management team members, are passive in the deal. So for the residential assisted living, all we do is just separate the real estate from the business operations. So there's a separate title holding entity if you're going to own the real estate. If you're leasing, I think Vern alluded to a company that buys buildings and leases them to operators. So let's say in that situation, you would just have the operations entity that would lease the building. So in either case, if you do own the building and also own the operations, we're going to have two separate LLCs for that. And the reason is because we always want to separate your liabilities. So you have separate liabilities for dealing with your residents and your staff and contractors that might provide services to your facility. And then you have different liabilities associated with just owning the building, paying taxes, having insurance, making sure it's in proper repair, and all of that. And then we would have this separate entity that's usually an LLC, where we're going to house our investors. And so we're back to that same structure we saw in the last slide. So it's a manager managed LLC, and then the asset manager itself is a separate LLC. And again, that's to separate liabilities. The only reason to have an LLC inside of an LLC is if you're afraid of being sued by the other members of the LLC. And, let that sink in a little bit. So if it's, if it's you and your spouse, well, you don't each need to have your own LLC unless, that's a different issue, right? Like maybe you shouldn't be in a business together. But, if you're dealing with, your co-GPing, we all hear that. When anybody's talking about the GP, what they're talking about is this asset manager entity that we're looking at right here. Okay. So this asset manager entity is the GP lingo is a holdover from years ago when everybody used to use limited partnerships. So limited partnerships were the things to do for 70s and 80s, and then LLCs came into effect. And the reason people like LLCs better than the GP LP structure is because the asset manager is actually inside the syndicate, so it gets extra protection, extra liability protection. Whereas in a general partnership or a limited partnership, you have limited partners who have their maximum liability that they could have for anything that happens within that entity is what they've invested. And but the general partner has unlimited liability for all acts of the partnership. So once we wrap it all inside this LLC structure and a member or a manager managed LLC, then the asset manager gets some of that protection that's within that LLC, the syndicate LLC. And then if the syndicate members were to sue the asset manager, then there's some protection there for the members of the management team, as long as nobody's actually doing something illegal or grossly negligent, then you're not going to be held personally liable. But illegal things could be violating securities laws because you don't understand them, or somebody on your team is actually, borrowing money from the company and when they shouldn't be, and then not able to pay it back, which is kind of your classic embezzlement, how that starts. So just, word of caution there. If you have multiple members in your asset management entity, everybody that should have some viewing rights to the bank account. You should be looking regularly. And if you see even one transaction that looks out of place, you need to question it immediately. As soon as you start questioning and people start knowing you're watching, they'll stop. But if you don't pay attention, it could go on for months or years. And all of a sudden, then you realize, oh, gee, all this money's missing. I should have been paying attention. And it's probably too late to get it back. So, and the problem with that is that if you're part of that management entity, you're just as responsible for it as the people that took the money. So you've got to pay attention to that. So I always say, don't ever let two related people have control of the bank account. Make it two unrelated people, so, one partner from this team and one partner from that team, and everybody's, watching each other. So, okay. So, just, if you were going to do, this is a different structure that we do. It's a little more complex. This just really, if any of you are familiar with a series LLC, it's like we write the main offering documents one time for a master entity, and then for each property and each group of investors, we create a separate series. Those are much shorter documents, a little easier to do. If you're not raising huge amounts of money, that's a way to contain your costs and continue to kind of replicate the same business model over and over and over again. So if any of you were to come to us and say, hey, we only need like $1 million for this deal, or less than $1 million, and we know we're going to do 2 or 3 this year, then we might introduce you to that particular model. And of course, we'd go into it more in depth. So you don't have to understand it, just know that it exists. There's a way that you can use the series LLC to kind of contain your legal costs and keep replicating the same model over and over again. So 2 ways that residential assisted living syndicates earn money. Of course, the residents pay the operating LLC. The syndicate owns the real estate and the operator LLC. That's the model I showed you, and splits all profits with investors. So those two, those title holding entity and the business entity, they funnel together into that syndicate. And so whatever profits there are after you pay your operating expenses, after you pay your building ownership expenses, pay your debt service, all that, whatever profits are left, you funnel into that syndicate. And then from there, you pay the asset manager fees. And the asset manager really has one job, and it's to take care of investors. That's all it does. It's responsible for raising the money, and it's responsible for making sure that the investors get their money back and get their distributions, and making sure that the building is taken care of, maintained, handled, and that the operations are being appropriately handled. And so the other option is to you buy the land and the building, and maybe build the building, or the building's already there. You make it right and ready to be leased to an operator, and then you lease it to the operator. And then you have your investors help you with the costs of buying and readying the building. And then whatever lease payments you get from the operator, then the proceeds are split with your investors. So a couple different models there. Some people like to be their own owner operators. Other people like to hire somebody to be the operator. So now let's talk about capital raising. So you kind of got the foundation for how these are structured. So again, don't get too concerned if that seemed really complicated to you. It's really just two LLCs. One, we're going to house investors. One is going to be an asset management entity. But the second part of that is that what are securities laws and how do they come into play here? So the Securities Act of 1933, which is still alive and well, has been revised many, many times. But that's when it came into being, was in 1933. And it first defined what securities were. Prior to that, there was a very disjointed state securities laws that said, hey, you can't defraud investors in our state, but somebody could defraud investors in Colorado and then go to Iowa and do it again, and there wasn't any cross jurisdiction. So after the stock market crash, the SEC was born shortly thereafter, and the Securities Act of 1933 came into play that said, what are securities? And so if you look at the Securities Act of 1933, there's about a half a page of different terms and phrases that are securities. And the two that pertain to real estate investors are promissory notes, which is the very first thing on the list in that definition. And then later on is something called an investment contract. So we're going to cover what that means in a minute. But we also, out of the Securities Act of 1933, they said you've got to disclose to investors all the material facts they need to make informed consent, which means you got to tell them everything about the deal, all the different things that could go wrong, anything about your background that might affect their decision to invest with you. You've got to disclose those things. It's the law, and concealing those things or misstating them or omitting them is considered fraud. And it's illegal to commit fraud within a securities offering. So you could, technically be prosecuted and go to jail for that. And it imposed penalties for violations. So the SEC was created with one position in mind, and that is to protect retail investors. That was its primary mission back in the 1930s. Right now, I was just fortunate enough earlier this week on Monday to be at a continuing legal education conference in Tampa, and the acting director, our acting chairperson of the Securities and Exchange Commission was there, and as the keynote speaker, and he said that they are looking at everything about the securities laws that are currently in existence, and with the eye that they want to make it easier and cheaper for small issuers of securities like yourselves to be able to do these securities offerings, and while also maintaining protection for retail investors. And so when we're talking about retail investors, we're talking about people like you and me, okay? Your neighbors, your family, your friends, acquaintances, people who have some savings and have maybe made some other investments. But we're not talking about like institutional investors. We're talking about retail investors, ordinary people. So anyway, one of the things they mentioned was that they may be relooking at the accredited investor rule and maybe perhaps offering some sliding scale based on income, where maybe more people would be given opportunities to invest in some of these deals that you're able to participate in. But anyway, so the other thing that the Securities Act of 1933 said is that the offer or sale of securities must be registered or exempt from registration. So registration, that's taking your company public. Okay, that's an IPO. And it requires filing a pile of paperwork with the SEC, getting pre-approval. There's usually a period where they're going to review the docs, ask you a bunch of questions. You're going to have to respond. You'll go back and forth a couple of times until they're satisfied. And then they'll say, okay, it's fine. You can sell these to the public. And they're going to ask you for, audits and, your financials and things like that, because they really want to make sure that you are able to do these, and you're not going to, fail because you're undercapitalized, or you don't have the right experience, you don't have the right people on your team. They're really trying to protect the public, because once your offering is registered, you can sell it to anybody without limitation, right? There's no limit on how much stock of a certain company somebody can buy under securities laws once it's publicly registered. So whatever, then you can put it on the New York stock exchange or NASDAQ, but you don't have time to do that. You don't have the 6 or 9 or 12 months that it will take to get your offering registered. So instead, you're going to try to qualify for an exemption from registration. And it governs, the reason I have that underlined is because it governs not just the sale of securities, but it also the offer. So when you stand in front of a room and you tell people, I've got an investment opportunity for you, if it's a certain type of offering that can't be advertised, then you would have violated that securities law right there, just by offering it to a room of people that you have not pre-vetted, you don't have pre-existing relationships with. So you've got to be careful about how you make offers and who you sell to. So, anytime you say, hey, I've got a deal, this is what we're raising money for right now. We'd like to have you participate. Any of those words are when you're into the realm of making an offer. Now, what's not making an offer? Telling people what you do. Hey, we buy assisted living facilities, or we build assisted living facilities, and periodically from time to time we have investment opportunities. That's okay. You can talk to anybody about that. That's just a general statement about what you do. You're talking about your company, but you're not saying, oh, and if you'd like to invest with us right now, we're buying this property over on 123 Main Street. That's an offer. Okay, so you see the distinction. We're talking about your company generically, not talking about numbers, not talking about a specific deal, versus, oh, here's the deal I have right now. Here's what we're offering. Here's how you can invest. That's a specific offer. So you've got to be careful. So what are securities? So we talked about the promissory notes and the investment contracts. All right, well, I think everybody pretty much understands what a promissory note is, but it's a promise to pay with certain terms and conditions attached to it. So it's going to have, a principal amount. This is the amount of money that somebody gives you. Then you're going to have some sort of an interest rate or something that you're going to pay them in exchange for using that principal amount for some period of time, usually going to be a specified period of time with a maturity date, and then maybe some payment schedule and some terms under which you will repay that note. If you fail to do that, either periodic payments, or you fail to pay it back when it's all due, then you would be in default. Every promissory note has a default provision that invokes a remedy. And so the remedy could be a foreclosure if it's something that has a property as collateral, or it could be they could sue you. If you've issued a personal guarantee, then they're going to sue you for the deficiency if they end up losing money. So But what's an investment contract? So an investment contract was actually decided back in 1946 in a legal case that originated in Florida in a little place called Howey in the Hills. And in Howey in the Hills, there were some Orange Grove operators who decided they needed to raise some money, and they got investors to invest with them. And then at some point they decided they didn't want to keep, well, so the idea was invest with us and we will continue to harvest the oranges and we will distribute the oranges and share the profits with you. And then at some point they decided, we're not going to do that anymore. Here's your, started sending letters to their investors. Here's your plot of land. Here's your tree. And the investors are like, no, that's not what we bought. We did not buy trees. We did not buy a plot of land. We bought a contract with you where you said you were going to continue harvesting oranges on our behalf and share the profits with us. And so at that point, this term investment contract hadn't really been defined, but the definition came out of this particular case as it worked its way up through the Supreme Court. When the final ruling came down, it said an investment contract is an investment of money in a common enterprise with an expectation of profits based solely on the efforts of the promoter. So you could have an investment of money in a common enterprise and an expectation of profits without having it be based on the efforts of the promoter. That's called a joint venture. So if all of your members are actively involved, then you don't have you're not selling investment contracts. But when you being the promoter, your asset management team is the one that found the deal, conducted the due diligence, is doing whatever renovations have to be made to make the property ready for its intended purpose, is organizing the operator, whether it's going to be your team or you're going to hire someone. That's the promoter, and you're the ones that are raising the money, and everybody else is just passively investing with you and relying on the asset management team to make that venture profitable. So that is a classic investment contract. Just in plain English, you have passive investors that are relying on you to make a profit for them. Okay, so anytime you get into that world of passive investors, and in the context of our structure that we looked at before, that manager managed LLC that we looked at is going to have an operating agreement. And that operating agreement is going to be the document that describes what the common enterprise is and how the profits are expected to be generated and distributed and where the money is going to be invested. So that operating agreement for that syndicate, okay, which is that investment group that we looked at, that is going to be the thing that would go to court if anyone were ever to challenge it. Right. So what is a syndication? It's really just organizing a group for a common purpose to promote a common interest or to carry out a particular business transaction. So you putting together your expertise and the expertise of your management team, and with the money from your investors, you're going to collectively go out and you're going to go create these companies and then buy this facility and operate it in a way that's profitable for everyone. So syndication versus joint venture. So back to, we have an investment of money in a common enterprise, expectation of profit, but all members are actively involved in generating their own profits. Now, it becomes very hard to defend a joint venture that has more than 5 members. In fact, I've seen disastrous results when people have tried to put more than 5 members into a joint venture. If you were to try to do a joint venture, you would use a member managed LLC where everyone is a managing member and no one designated person is getting a larger share of profits for their active role while the others are passively involved. And then that therein is the primary distinction, is how you can make money. So who doesn't follow securities laws? People who don't know, people who don't care, people who are in denial, or people who are in jail. Don't know, you can't be that after you've listened to this presentation. Don't care, well, if you find people that don't care, then you just don't want to be near them, because they're a disaster waiting to happen. And if you invest with them or you are partners with them in a deal, it's not likely to end well. And then in denial, I have met a lot of people over the years who just can't believe that all this applies to them. And I think the worst case scenario was a woman that I had a conversation once with after she illegally solicited me for an offering that she was doing. And I said, I'm not your attorney, but you might need one because you really can't do that. And she said to me, "You're like the fifth person that's told me that." So, if you hear it 5 times, you might want to pay attention, just saying. And we certainly don't want to see anybody go to jail. But yeah, people that go to jail are people that steal. And for whatever reason, we all hear about them. The really bad ones make the news. Bernie Madoff was probably the biggest example ever. But it's kind of crazy because it seems like there's kind of a path towards going to jail, and it usually starts with posting a lot of pictures of themselves with really fancy cars and jets and things like that on social media, and things tend to go downhill from there. And the complaints, I read the SEC complaints, always read so and so raised sometimes it's a staggering amount of money, like 15-20 million dollars, and used it to buy expensive vacations, expensive cars, and expensive houses. So they always use the money to enhance their lifestyle and don't do what they said they were going to do with the money. And then they get into the classic Ponzi scheme, which is where they're trying to bring in new investors to pay back the previous investors who are now asking them, "Hey, where's my money? How come you're driving around in a fancy car and riding private jets, and I'm still driving a Camry?" So don't do that. And don't post it on social media if you do. Yeah. So when do securities laws apply? So when you're raising money from passive investors, if you're selling LLC interests to passive investors, even corporate shares are securities. So if you have a corporation, you're selling that, you're not going to use that for real estate, but in other contexts, those are all securities. And repeatedly borrowing. So if you're just borrowing money one time from, a family member or close friend or something like that, nobody cares about that. It's when you're in a business that depends on borrowing money from ordinary people at your RIA, people at your meetups, people in your community that when you start doing that on a regular basis, then you are in the realm of securities laws. So examples, anytime you create a manager managed LLC and your members are contributing money, then to buy LLC interests, you're selling securities. Limited partnership interests, again, if they're contributing cash, by definition, they're passive. They have to be passive in order to retain their limited liability. Corporate shares or stock. Tenant in common interests, if there's an asset manager that is, a certain group that's going to be generating profits for the whole group, then those would be as well. And so just think, anytime you have a passive investor, they're not going to be actively involved in making the investment decisions. So how do you follow securities law? So either register the offering, you're not going to do that, choose an exemption. And so each of these exemptions are self-executing exemptions. And we're going to talk about those next. So this is usually the one that most of our clients start with. Regulation D, Rule 506B, where you can raise an unlimited amount of money. You can have an unlimited number of accredited investors. Accredited investors, will cover that definition in just a moment. And you can have up to 35 non-accredited but sophisticated investors. So sophisticated means more than just somebody with some savings and a job. They have to have some, background, investing experience, training. Maybe they're regular members of the local RIA or of this group where they've learned about these things. Then they could qualify as sophisticated. And, but the thing about Reg D Rule 506B is that you cannot find your investors through any means of general advertising or solicitation. And the way to prove that you didn't solicit publicly for these investors is to be able to demonstrate that you have a prior relationship. So they call it a pre-existing substantive relationship. So pre-existing means it predates the offering and before you had the deal. Okay, before you had the deal. Substantive means the suitability is determined before the offering exists. So that means that you have to have a conversation with every prospective investor, asking them, are you accredited? If you're not accredited, tell me how you might be sophisticated. And, you can give them the definition of sophisticated. And then, they'll say, oh, yes, I am, or no, I'm not. If they're not, then they can't invest. If they say, yes, I am, then you can ask them further questions. Well, how is it that you think you're sophisticated? And they'll say, oh, because I have a business degree or an economics degree, or I've owned small businesses, I've owned other investment real estate, I've been going to my RIA for 10 years, whatever it is that they want to tell you that they believe makes them sophisticated is what makes them sophisticated. So as long as it's not somebody who just says, no, I just have some savings and a job, I've never done any of this before, I don't know what it means. You don't want those people. And you want to help those people become sophisticated by encouraging them to come to these groups and learn, so then they can invest with you. Okay, so who can invest? We talked about accredited. That's right now somebody with $1 million net worth, excluding equity in their primary residence, or $200,000 a year income as an individual, or $300,000 for a cohabitating couple. So as long as they're either married or sharing the same address, that would qualify. And it has to have been for the last 2 years with an expectation it will continue indefinitely into the future. Sophisticated, somebody with sufficient business or financial experience to understand the risks and merits and can afford to lose the money. So you don't want to take somebody's last $50,000, and you don't want to have people depending on your returns to support their lifestyle. This is one of the reasons we never recommend that you ever pay people monthly, because if you pay them monthly, they start, thinking, oh, well, I'll get my payment next month from my investment, then I can go buy this car. And then all of a sudden you have to suspend distributions because something happens or something shifts in the economy. And all of a sudden they're, in trouble. So you don't want people who are depending on you to support their lifestyle. So that's part of what you want to ask them about before you allow them to invest with you. So, we have an article on our website. If you go to syndicationattorneys.com, there's a whole resources page or section that is very extensive. But in it, if you type anywhere on our website the word substantive, okay, for the substantive relationship, you will find that article on how to create a substantive relationship, and it has an attached list of prospective questions that you would ask someone during that suitability conversation to make sure that they're suitable. Once you've had that conversation, you also have to document it. All right, so you're required to keep some kind of a record-keeping system to show when you had the conversation and when you started making offers. So from after you have that conversation and you learn about that person, you now know whether they're sophisticated or they're accredited, and non-accredited but sophisticated. Then you would be able to offer them any deal. Okay, now you don't have to just talk to them about what your company does and what you do in general. Now you can say, hey, we're buying this property at 123 Main Street. If you'd like to learn more about it, we're going to have a webinar. We're going to tell everybody about it. And then if you'd like to see the offering documents, we're happy to send those over and walk you through them. So, okay, so what is in a securities offering? What are the documents that we create for you? The first thing and the most important thing, according to the SEC, is called a disclosure document, and it's affectionately known in the industry as a private placement memorandum, PPM. Okay, the rules, the SEC prescribes the some of the content. They say it has to have these things in it. And, you know, one of them is about 7 pages of risks, all the different things that could go wrong. Hey, the economy could change, the regulations could change, somebody could get hurt, somebody could die, you know, the building could get damaged in you know, some environmental thing, you know, whether it's a hurricane or, you know, wind damage or fire, you know, all things that we've seen in recent history. You know, something could happen. You're going to talk to them about all those risks. And if one of those things happens and it causes the investors to lose all or part of their money, they cannot hold you responsible for it, because they're going to assert to you in their subscription agreement that they've read the private placement memorandum, they understand the risks, and they can afford to take the risks. They've asked all the questions that they had of you, of their own financial advisors, of their own attorneys or accountants, and here's how much they're going to invest. So that's what that does. And it tells you they can afford to lose the money. The operating agreement, again, that's going to be that document that we, so the PPM really is an operation while you're raising the money, tells you how to raise the money, who you can raise it from, what the risks of the investment are, all of those details. The operating agreement is the governing document for your company. So from the day that you start operations to the day that you give everybody their money back, sell the property, and dissolve the company, that is how you're going to operate your company, and you cannot deviate from that, usually without getting permission from your investors. There's going to be very few reasons that you would be allowed to deviate from that without their consent. Right. And then the investment summary. So we like to have our clients create a standalone investment summary that describes the investment in plain English with pretty pictures. And this is where you're going to put your pro forma for the property. You're going to create something called a sources and uses of funds, a 5-year pro forma for how long, you know, every year by year, how you're going to income and expenses, what you've projected, showing what's left over for cash flow and how that's going to be split up between the investors and the asset management team. And then you're also usually going to provide some kind of an exit strategy. So it's like, hey, we plan to hold the property. And I was telling in the breakout room earlier, I was talking about that you don't want to ever say you're going to sell a property in 5 years. You always want to give a range, 4 to 6 years. Okay. And the reason for that is if you tell people you're selling in 5 years, then you're going to get all of them calling you in 5 years in one day saying, where's my money? So you don't want that. Tell them we're going to sell it within this range. You're never going to know how long it's going to take to sell. And the market conditions could be wrong so that you don't want to sell at that time. Or maybe you get an unsolicited offer that's, you know, crazy amount of money 3 years into the deal. So you decide it's in the best interest of the company to take it. But anyway, the investment summary is where you're going to talk about, we think we're going to sell it around year 5. Here's what it might look like. And you're going to have to make a whole lot of assumptions when you're creating those numbers, and you're just going to write them all down. Here's all the assumptions we made. We thought that we would buy it at this. We're going to increase our, you know, our income by this every year, or, you know, these are what we think our expenses are going to be. And, you know, if we do all that, this is what we think it could be worth when we go to sell it 5 years from now, assuming that the cap rates are the same as what they are when we bought it. You know, so you're just going to write all those assumptions, because in the PPM, we're going to have a risk disclosure in there that says, hey, every likelihood that our, you know, our projections are going to be completely wrong. And the only guarantee here is that whatever projections you make, you will never hit those numbers. Right? You'll never be exactly on point with that. But you're trying to give a conservative estimate, and ideally, you want to under promise and over deliver. And then we would also do securities notice filings for you. There's a form that we file with the SEC telling, it's called a Form D, telling them which exemption you're choosing, so they know which rules you're following. I mentioned that these are self-executing exemptions. So that means that you have to provide, you can claim the exemption, but you have to provide the documentation on how you actually complied with it if you were ever audited by securities regulators. And you know, that you just have to be prepared to be able to do that. So you want to have all that documentation in place. You want to have all your subscription agreements and all your documentation that's been signed by all of your investors, and all of your records on when you met them, how you met them, when you started making offers, and what offers or what ads you made. We actually just created a securities advertising guide, which is astounding, the number of words that they don't want you to say. Things like how you progress.
Showing him dancing at a building with a sign for Trump.
So 4 traits of successful investors, successful syndicators: competent, trustworthy, likable, and transparent. So you need to be those things, you know, collectively as a team. You know, those are the things that your investors are looking for. And so what we do, we create syndication docs, fund documents, joint venture documents. So the joint venture we were talking about, you could use that for the asset manager. Your asset management entity might be a member managed LLC. And so you can use that as long, and I never recommend more than 5 people in management of a syndicate. And here's why. The money gets spread too thin. Nobody makes enough money. Everybody's upset. 3 people end up doing all the work. The other 2 are along for the ride. So, you know, make sure that you're, when you create any kind of an asset management entity, give everybody a written job description with the understanding, and have it written into your documents, that if they don't or can't perform the job, that you will be able to remove and replace them. And that you don't necessarily owe them anything other than what they've invested in the syndicate, and they'll get paid that back when everybody else does. So we do have some low-cost pre-syndication agreements where you can get involved with us, starting as low as $1,000. We do have weekly masterminds, all led by an attorney, and where we're, you know, constantly trying to educate our investors on, you know, what you can and can't do, and, you know, discussing all these topics related to deal structures and capital raising, so that you can all be successful. So, check out our podcast, Raise Capital Legally. Please leave us a review if you like it. Stop by our booth. Well, we don't have a booth here today, but this was the presentation that I actually gave when Vern saw me speak at the Brown NatCon. So I think got a more in-depth review of it tonight, so we had a little more time. So, but happy to open this up for Q&A.
Anybody have questions? Come on now, don't be shy.
Yeah. Don't be shy. Don't.
I'll ask a question. So what happens when you're a one-man band, basically? So it's your business and you don't have all these other partners and all these other members and things like that. So how do you set that up?
Well, you've got 2 issues there. One is the job is too big for one person to do alone.
Okay.
And the problem is, what if something happens to you? How are the investors taken care of? So if you don't have an actual partner, then you may want to appoint somebody who will step in the event you are incapacitated. So you've got, your investors are going to want to know, what if something happens to you, who's going to take care of this? So, you know, if you think about, there's a lot of jobs we covered there. Okay. So, you know, just back to this book, you've got to have someone in charge of raising money. You've got to have someone in charge of, you know, creating, finding, you know, and making the facility ready. And you've got to have somebody in charge of making sure that the facility is running correctly, and also in charge of investors. That in just one facility could be a full-time job for one person. So if your goal is to have more than that, you're going to either need to have paid staff, or you're going to have partners. Paid staff, of course, you know, costs you money out of pocket, maybe before you're making money. Partners, you know, don't have to be paid until the project makes money, it's profitable. You know, so most people do end up with partners. And the people that do have paid staff, problem is it's very hard to keep them because at some point they see what you're doing and then they go do it. Yeah.
My next question is I've heard of individuals who set up syndications, and I guess they kind of manage it, like they have a group of investors that they work with, and I guess it's their syndication. So how would that work for a business person that I'm looking for investors, and instead of me trying to set up a syndication, I work with someone who already has a syndication created, I guess.
Anytime you let somebody else bring in the money, you lose control. Okay, so let's think of the Shark Tank model, right? You're standing in front of Shark Tank, you're pitching your deal. They're not handing you $500,000 to just go spend as you want. Okay, they're handing you $500,000 with a bunch of strings attached, and one of the guys from their team is going to be in your office telling you what to do with money, how to spend it, what your next move is going to be. So anytime you've got somebody who's bringing in money like that, there always are strings attached. And either they're going to be in control of the deal, you're not, okay, where you're just an operator that could be, and you're going to give up a whole big share of the profits to them. Or they're going to ask you for a whole bunch of reporting. You're going to have to give them monthly reporting on, all different kinds of things that are going to be very time consuming. And you're going to need to have somebody that's responsible. You're going to have to hire somebody that just maintains those reports usually. So money doesn't come without strings attached, even if it's your own investors' money. But if the clients of ours that are the most successful, the ones that go on and do more and more and more deals. We had one client that did 26 syndicated multifamily projects. We have other clients that started in 6 years, went from doing $3 to $5 million properties to doing $30 to $50 million properties. They all started with a team and usually, stuck with that team, and they might have switched partners at some point along the way, and there's nothing wrong with that. But they all, if they got rid of their partners, it's because they built their own staff. And the ones that have done it the best have gone out and developed their own databases of investors. And so the SEC says the median raise for a Reg D Rule 506B offering is $2 million with 14 investors. So if, let's say, you need $1 million, well, then you're going to have 7 investors, seemingly, but you probably need 3 or 4 times that many people in your database that you can approach about your deal to get that many people to invest with you. And then your first deal, it may be even more. So even if you only want to raise $1 million, you think it's going to take you 7 investors, probably not. It's probably going to take you 10 or 20 on your first deal. Most of our clients start with $50,000 minimums. And, if you tell people, hey, it's a $25,000 minimum, then you're going to have twice as many investors. If you tell them it's $50,000 minimum, and, maybe we can make an exception once in a while, then, you're going to get mostly $50,000 investors, and some will invest more. So that's ideal for you. So, you raise $1 million, your first time it's going to be hard. The second time is going to be easier, but your job, if you think you're going to be needing to raise capital going forward and to do as many deals as you want to be able to do, is to figure out how many investors do I need, and go about create an investor marketing plan about this is how I'm going to get those many investors pre-vetted, ready, stay in contact with them so they're ready and willing and interested in investing with me when I have a deal. And so that requires some effort. And so this is why it's not just, it's really kind of 2 businesses. One is operations, one is capital raising. And most people aren't good at all of those things. You're really good at deal underwriting. You might be really good at managing people, but you're not as good at, you're not the social butterfly that has, 1 million people in your phone and, constantly on social media. That's who you want raising the money for you. But
Thank you.
Yeah, great questions. Just think about continuity. Who else has some questions? Anybody?
I'll bring one up.
Yeah.
What do you see as a typical charge for the asset manager? What do they charge the syndication?
So there's I've got an article on our website called 12 Ways Syndicators Make Money. I think it's also in the book. So typically you're going to get paid a number of different ways. So there's going to be fees, and there's also going to be a share of profits. So the fees are not where you make the bulk of your money. The profit share is where you make the bulk of your money. But the fees are what keep you from starving between the time that you start doing the deal and the time that there's actually profit to split. So you could get an acquisition fee that's usually 1 to 5% of the purchase price of the property. The smaller the deal, the higher the percentage. So 5% for maybe a $500,000 deal, and 1 to $3 million deals are going to be like somewhere in the 3% range. If you get it to a $5 million deal or above, then maybe it's going to be like 2% or less. Okay. $10 million deal, maybe it's just 1. So just kind of a sliding scale. So the point is, though, that you have to raise enough money from your investors in order to pay for the down. So assuming you're going to get a bank loan, all right, always get a bank loan, because the bank is your cheapest investor. All right. Even if they want 8 or 9%, your investors want double that. So you always want to get as much money as you can for your project for the least cost. So get a bank loan for as much as you can. The down payment you'll raise from your investors, plus there will be some closing costs. You'll raise those from investors. You'll need some money to renovate the property and get it to set up correctly. So you'll have a capital improvement budget, and then you'll need some working capital and reserves. And then sometimes you'll also need some loan fees, pay the lender so that they can do their due diligence. They do the appraisal, all that stuff. You're gonna have to pay them those fees. And then you're gonna have legal fees for us. You should be planning, $15,000 to $20,000 for legal fees, filing fees, forming your entities. The securities notices that we file, the federal one doesn't cost anything, but the states all have fees. So every time you bring in investors from a new state, then we have to file a notice with that state, and those fees can range anywhere from nothing in Florida to $1,200 in New York. Most states are $300 to $500, and you pay those one time for your first investor from a new state. So you're going to have some fees in there. So just budget $15,000 to $20,000 for your legal fees. And, and so anything that you spend on the property up front, those are all reimbursable expenses. Anything you can produce a receipt for. So, if you have travel expenses to the site, whatever other, you've had to hire somebody to conduct some kind of an audit or a property inspection or something like that. All those are reimbursable expenses, but you're going to use your own money to get the deal to the closing table. So until you close on that deal, you don't use investor money, because if you don't close on that deal, it's your money that's lost, not theirs. And then you have to give their money back without deduction. So that's, so it's the asset management team that puts up that at-risk capital in order to get the deal closed. And so if somebody ever asks you, an investor ever asks you, what skin do you have in the game? It's like, well, it's first of all, the training I went through to learn how to do this, all the seminars and conferences I went to, and the books I read, and all the materials and coaching that I got, plus all the money to get this deal to the closing table. That's what I've got in the deal. And you can also contribute cash if you want, of course. So anyway, those are your acquisition fees. Asset management fees, usually 1 to 2% of gross collected income. That's not the same as your operations management fees. Okay, that's a completely different thing. We're just talking about what are you getting for babysitting this deal on behalf of your investors. That's your 1 to 2% of the grossly collected income as an asset management fee. The financing fee. So if you have to personally guarantee a loan, or even a non-recourse loan, like if you were to get a HUD loan or something like that, still requires you to provide loan guarantors that have net worth equal to or greater than the loan amount. So those are people you also need in your asset management team. The lender will want to see them in the asset management team. So if you don't have the ability to sign up and guarantee all those loans yourself, you're gonna have to bring somebody in that can. Loan guarantor fee, usually it's part of the acquisition fee when you purchase, but you can do a refinance fee in case you decide to refinance later on. Then it's usually 1 to 2% of the loan amount. A disposition fee, 1 to 3% of the sale price. So usually going to be kind of similar to what your acquisition fee was. It's just to make sure that you don't end up dispersing all the money to investors without you getting anything at the end. You can always waive fees, but if they're not in the documents from the beginning, you can't take them. And sometimes it could be a really long time before there's enough distributable cash, is what we call it, to be able to make distributions to your investors. So then you'll get a share of the profits from cash flow, ideally, and a share of profits from the sale. So that's all going to be driven by what kind of overall cash on cash return the project generates. And so let's say you calculated out your pro forma and your proposed exit strategy, and you say, all right, so we think that we're going to end up having overall when you combine all the money that came from cash flow plus all the money that was left over after you paid off your expenses of sale and your loan, add all that together, divide it out over the years that you've had the property, that's going to give you a number, right? So we made this much every year, and then you're going to compare that to the original amount of money that you raised. So if you raised $1 million and then you figure out how much we made on that $1 million every year after we paid that $1 million back, then you're going to know what your cash on cash return was, and you're going to reduce that to a percentage. So I know this is kind of technical, but that's why I'm going to encourage you to read about it in the book, because it's really explained better there. But also you can just go online and probably, I'm sure there's a million YouTubes out there about how to calculate cash on cash returns. But it's going to become important because you need to know the overall cash on cash return for your project, because that's going to tell you how much of that project you have to give to investors. If you have an overall cash on cash return of 20%, then you want your investors to have 15, then it's a 75-25 split. Okay, you get 25% for asset management, they have to get 75%, or they're never going to get the 15% you want them to have. So learn how to do cash on cash returns is going to become critical when you're using investors to figuring out what your splits are going to be and what you can offer them. And it's also going to help you determine right off the top of your head whether or not you can even do the deal. Because if you never get to 20%, it's not worth doing. All right. So if you're never going to get a 20% cash on cash return, you can't do it with investors. You could maybe do it by yourself if you had the cash to do it, but you don't have enough money to give investors.
So a lot of the deals I analyze are like turnarounds in larger assisted livings, and usually it takes up to year 3 before we start seeing those numbers. And year 1 and 2, they're nil, basically. We've got to get enough cash just to get through the operations in that. Based on what you've seen, how does that go over with some of the investors to know, well, we're not going to get anything for the first 2 years, but then we're going to start seeing decent returns.
You just have to explain that to them. That's what it is. For development projects, they expect that. People who invest in development projects absolutely expect that. For turning around an existing facility, I would think you would get there a little faster than that. But at least have enough to pay your investors, maybe not yourself. So you might have heard this term before, a preferred return. All that means you give 100% of the cash to investors until they hit a certain benchmark, and then you're going to take your cut. So if you have said, we're gonna give you 8%, that just means you get all the cash from operations until you get the 8%. And if there's nothing left over for me, then we'll make it up later, or maybe I just don't get it. Ideally, we always want you to use what's called a Class B catch-up. And again, that's going to be explained in this book. So that you end up going back when you sell the property and say, okay, we didn't get anything in year one, we can make that up now. We didn't get it, we got only part of what our 25% for year two, we're going to make that up now. So this preferred return concept means their returns accrue whether you're making the money to pay them presently or not. So if you can't pay them in year one, they're 8%, then you still owe it to them, but you don't pay it until you either refinance the property or you sell. And it doesn't compound. But
Great.
ideally, we'd like to have you, set it up so it's, hey, it's a 75-25 split from the beginning, but in the early years, we're going to give up our share in order to get you to 8. And then from once you get to 8, then we're going to go back to our 75-25. And you guys just make sure they get their 8, you take what's left. And then if there's anything over that, once you get to 8, they got their 8 and you got your share, then you're gonna just go straight 75-25. And then you can also add a cap, because I know some of these assisted living deals can get pretty lucrative towards the end. And if they do, then you want to have a cap for your investors. Usually I would cap them around 20%, to where once they get to their money back plus an annualized return of 20% per year for all the years that you've had their money, then the split would change and it would either go to 50-50 or it would go 25-75. Keep them in the deal though. Okay. It's always a mistake to cash out your investors. Keep the deal, because if people feel like you got a windfall and they got cut out, they're going to think they got cheated. But if you change the split and leave them in, even for a small amount of money, they've got all their money back. They got a 20% annualized return. Plus they're still getting money in the mailbox. These people are raving about you to their friends. They can't wait to do another deal with you. And that's what you want. You want investors for life that will come back to you again and again and again and bring their friends.
Great. That's very helpful.
Yeah. Tammy had a question. For the successful groups you observe scaling up, it sounds like the right team members are essential to success. How did some of them find their team members? Well, they came to us already a team. 2 of them did, and then one of them later on ended up adding their son. So now it's a 3-person team. The other one started with a team, ended up having, started with a partner, ended up, that partner kind of did some things they shouldn't have been doing. So they ended up divesting themselves of that partner and then built out a very robust paid staff. Yeah, okay. And then Dave asks, if you don't have enough assets for the bank loan guarantee requirements, what is reasonable to pay investors who will be part of the loan guarantee? So I have a little formula for that. And again, that's in the book. I like to think of the asset management like a pie. Okay. And we're going to cut it into 4 slices. And we've got the first, upper left quadrant is finding the deal and, all the stuff you guys are doing now to get to this point. This is finding the deal, conducting the due diligence, making sure the deal's a go. The upper right quadrant is for the people that are in the deal long term. You're the ones who are making sure everything happens and overseeing the operators and making sure the property is maintained. And then the bottom half, the lower left quadrant is for your loan guarantors. So 20 to 25% is what you should expect to pay loan guarantors. If you need more than one, it would be split between them, or if you are one of them, it would be split. You would get part of that. And then the lower right quadrant is for bringing the capital. So just think of it like that. But ideally, you should have a piece of each of those quadrants. And the more, so the more of it you have, then the more of it you get to keep for yourself. So, just be very careful. You don't want to pay people to bring money to your deals. You cannot pay commissions. It's illegal for you to pay any amount that's based on the amount of money somebody brings to you, unless they are a licensed securities broker dealer, and I can guarantee you they will not invest in your deal. Those people will not invest in your deal. Don't waste your time with them. The other thing, do not waste your time with single check writers unless they're like a family member. Because they don't come through. They will either 99% of the time they either don't come through. They talk a big game, they'll say, you'll be talking to an investor and they'll, oh, I could write the check for the whole amount. And your response to them should be, I know you could, but I'm not going to let you. And the reason I'm not going to let you is because I want, first of all, if you put in more than 20%, or your lender's going to have some percentage threshold that if somebody owns more than this percent, they have to help guarantee the loan and be underwritten on the loan. And your passive investors won't want that. So that's number one. Number two, you don't want them to feel like they own the deal. So if they feel like they own the deal, then they have sway over other investors, then they have sway over you, and you now work for them. So you don't want that either. So a lot of our clients will just limit people to whatever the lender threshold is. Often it's 20%. Small banks, if you guys are using like local credit unions, things like that, they can be as low as 10%. So you want to be just cognizant of what is that number, so that you make sure that nobody has more than that percentage that you don't want to have in management with you. And then if somebody does want that responsibility, then say, well, that's fine. You can be in management, but as part of management, you cannot just bring money. You are expected to do things. Here's all the jobs. Which ones are you going to do? And so that is the rule. If somebody brings you money, don't pay them based on the amount that they raise. Pay them for their jobs. Nobody gets compensated just for bringing money. They all have to have other jobs, and that's what they get compensated for. There's several articles about that on the website. There's stuff about it in the book as well. So I would encourage
Were you
you
seeing,
all to go get the book at the website, at least get the electronic version. And if you decide you want more, then get it on Amazon. But it really is a great resource for you, and you're going to be referring to it again and again and again. So a lot of people would just want to have it on their desk.
do you see Tim's question there about SEC licensed brokers? I think it kind of ties in with what you were just saying.
Third party, yeah, it is. So if you can find one that would actually do your deal, and chances are they won't. So broker dealers have a fiduciary responsibility not put their clients into unsuitable deals, which means that they typically won't even look at a deal that doesn't have like a $10 million raise, and then they're going to charge you about $100,000 just in due diligence fees so they can review you and the deal to make sure it's suitable for their investors, and then they'll go do it. So I've been doing this since 2008, and I've only known of two people that have used broker dealers, and they both owned the broker dealer. So, people don't really use broker dealers in this space. It's just kind of a waste of time. But the biggest waste, again, is those single check writers, or the what I call them the whale investors, because what happens with them is that they'll talk a good game, and then they won't come through. But they usually don't come through when you're too close to closing to get anybody else. And so you've got a bunch of money out, they aren't coming through, and now you're stuck and you can't do the deal. I mean, worst case scenario, I saw some people that had spent over $100,000 on a multifamily deal trying to get it to the closing table, and the $400,000 investor didn't come. So they either don't show up, they stop answering the calls, or I've heard this story a bunch of times. Oh, geez, something happened with one of my other businesses. I just can't do it. I just can't do it. So there are some crowdfunding platforms But again, most of them are pretty picky about who they'll take. They usually take the top 5% of all the people that come to them, and they analyze hundreds of deals a month. So they're looking for people that have a really significant track record. So the best advice I could offer any one of you is, if you haven't done this before, do it with somebody who has. All right, get somebody like Vern on your team, and or join Vern's team, and don't be afraid to put in some sweat equity for Vern, just to learn the ropes and to get your name on the management. And I don't know if he does that or not, but you need somebody. You can get your own experience, or you can leverage off other people's experience. That's how I got started in this field. I met somebody who was already doing syndications. I started working with him. That way, when people said, well, what do you know about this? I work with him. He's been doing this for all this time. Okay. And then eventually I have my own experience. But that's the best thing you can do, because then you're not going to make $100,000 mistakes with other people's money, which is really painful. I spoke to somebody today that said, yeah, I lost $4 million on a deal, and now I'm trying to do new deals and see if there's a way to make those investors whole.
Mm.
That's going to be, he said, I've told the investors, I expect it's going to take 5 to 10 years. So the next 5 to 10 years of your life, you could be spent making people whole. If if you can get a coach, or get, an advisor, get team members that have done it before, then you're less likely to run into that. So
Good stuff.
yeah.
Any other questions? Going once.
Okay, well, reach out on our website. You can schedule a call with one of our team members. You can schedule a paid consult with me, or you can schedule a free call with one of our staff. And we're happy to talk to you about our pre-syndication programs. Please reach out to us if you have any questions about any of this. Happy to answer your questions. And we want to see you guys succeed. And I like the assisted living world. I think it's fantastic. I mean, I was super inspired by Priyanka and her, not only do we house the people that need the homes, but we also take their dogs. I thought that was pretty fantastic.
Kim, thank you so much. I know it's really late for you too, so I appreciate you staying up late and sharing your knowledge with us. That was a great presentation, and hopefully everybody learned something. I know I did.
Excellent. All right.
All right, we're going to wrap it up. I do have, last off is our haves and wants. If you are a vendor and you have a service you want to share with the group, or if you're somebody looking for a partner, this is haves and wants, and it's an opportunity to chat with the group. Does anybody have a have or want? Anybody?
Priyanka had another question. I can answer that really quick.
All right.
Priyanka, question: why would you syndicate and give away 20% when you can get hard money loan for a lower percentage? Because they're not going to do 100% of the deal. So you have to syndicate the rest of it unless you have your own money to do it with.
Terrific.
All right, everybody.
Okay, thanks everybody. We will see you next month, and appreciate you attending tonight. Thanks again, Kim. This is great.
Nice to meet y'all.